Thank you for joining us today. This is Chad Parmeter and founding member of Mirrors Planning over here in Kirkland, Washington. Hopefully everybody made it through the windy evening and morning. We had a couple trees come down here in our office, but we survived and we have power, and the chainsaw just ended about 5 minutes ago from cutting down the tree. So we appreciate you coming and joining us on our Mirrors quarterly webinar series that we do every quarter. It's our first quarter of 2025. We hold these quarterly events typically to have subject matter experts discuss relevant and what we hope are interesting matters for the people that we serve beyond financial planning, because we know you all have interests in other things besides investing in your financial world. And we think that bringing experts about other items that we're maybe not experts about is a useful time spent for most folks. We have a few housekeeping items before I introduce our speaker today, Jared Adams. We expect the presentation officially to go around 45 minutes or so. We may have some Q&A at the end. Although as we progress through the presentation, I do encourage people to use the chat or the Q&A at the bottom of the screen on the webinar to be able to put in any kinds of questions or comments that you have. We may interrupt as we go along, or we can wait till the end. It's going to depend on how that all goes. So enough of me talking. I want to first thank Jared for joining us today. He is one of the better estate planning attorneys that I know here in the Seattle area, and I always appreciate the way that he explains things in easy to understand ways. Now, what's going to blow you away is his background, because you wouldn't think with all of his technical skills that he would be capable of having those easy to understand conversations. He does have a solid background. He's a graduate of the University of Washington, where he received a Bachelor of Arts degree in Business Administration, cum laude. He has his Juris Doctor and Honors in Law, Order of the Coif, and a Master's of Laws in Taxation. He's a founding member of Condie Adams, which used to be in Kirkland. Now their offices are up in Bothell. In addition to his law practice, he's an adjunct professor in the LLM graduate program in taxation at the University of Washington School of Law, where he teaches courses in estate planning, federal, state, and gift tax, and federal income taxation of trusts, estates, and beneficiaries. Jared is married, has 6 children, and resides with his family in Snohomish, Washington, where I understand he lost power overnight, but he has made it to our session. And Jared, I have the first question for you is, how long have you been married?
I have been married for 27 years.
All right, congratulations.
Yes.
That's
Hey,
fantastic.
don't tell my wife that I had to think about it for a second.
That's all right. That's all right. Well, we really appreciate you speaking with us and kind of bring some common sense to estate planning today. So thank you so much for joining us.
Well, thanks for having me. I will take just a second and share something that I'll put my slides up. But I guess I want to share with everyone that my primary goal today is to educate. I really want people to leave this discussion feeling like they got a good education, things that they could understand on estate planning. And so even if you leave today and you send feedback to Chad and say, hey, Chad, the jokes weren't that funny, his timing was off, or whatever else, that's okay, right? As long as you say to Chad, but that was a good education. If that's what Chad gets as feedback, then I will feel like I've accomplished my goal today. I want to approach estate planning today, giving you tools, a systemized way for you to consider your own estate planning, whether it's planning that you have now or planning that you're considering doing, but a systemized approach to thinking about the issues and pros and cons and things that need to be done within an estate plan. Let me get my slides up now, just a second. And Chad, are they up?
They are up.
All right, perfect. So I won't finish the quote here that's on the slide, but you can guess what those 2 inevitable conditions of life are. There's been talk that Leo Tolstoy said death was one of them, and I think we've just inserted taxes as the other. I don't think that's what the original quote said. But I want to talk about estate planning today, and I want to talk about your planning in terms of 3 phases of planning. when clients come in and I'm working with them, they have a big stack of documents in place. They say, look, I think all these documents are my estate plan. And I say, yeah, those are estate planning documents, but I want to break them down into 3 different categories or 3 phases of planning that need to be done. The first category of planning is what I call personal planning. This is the part of the estate plan for each of you personally. It's not what happens after you die. It's taking care of you if you're still alive, but you're unable to care for yourself. And so again, it's personal to you, it's unique to you, and it's for you while you're still alive. The second category of estate planning is what I call asset distribution. We could call personal planning a euphemism for incapacity planning, right? It's a part of the plan if you're incapacitated. And asset distribution would be a euphemism for the death part of the planning, right? After you pass away, what are the legal documents that settle your estate, that move the assets from you to your intended beneficiaries? And then the third part of the planning I want to talk about today is what I call beneficiary care. My kids, all 6 of them who rarely agree on anything, would all agree that this is parenting from the grave. And there's some truth in that, right? This is the part of the estate plan where you're saying, I'm leaving this to kids or other beneficiaries, but with strings attached. Now, my kids joke about it being parenting from the grave, but it's more than that. It's not just parenting. This can also be for spouse or for others for tax reasons, right? You're going for certain tax benefits or for creditor protection or asset protection, right? There's also that element, as I said, of parenting, but it's much broader than that. It's retained control after death for accomplishing some designated purpose. So those are the 3 big categories of planning that I want to break your estate planning into. So let's go through those one at a time. The first one, the personal planning documents, consist of 4 key documents in an estate plan. A general durable power of attorney, which is for financial decision making, a healthcare power of attorney, which is for medical decision making, a living will, which is not a will or a living trust. Attorneys call it a living will because we're bad at marketing. A living will is an end-of-life declaration. It's something that's talking about your end-of-life care. So again, very separate from a will or very separate from a living trust. It sounds like them, but it's not. And then the fourth legal document we're going to talk about for personal planning is the HIPAA authorization. And this is more or less a permission slip for doctors to release medical records. So those are the 4 we're going to cover first. Let's go through them in more detail in that order. The first one is the general durable power of attorney. And again, this is the legal document where you appoint others to act for you for financial matters if you're still alive but unable to act for yourself. And I tell my clients with a durable power of attorney, whether I'm drafting a document for a client, reviewing an existing document, or whether the client is working with a third party, a real estate agent, a financial advisor, accountant, another attorney, every durable power of attorney centers around 3 key decisions, right? Whether you're preparing it or using it in real life, everyone's concerned about the same 3 key issues. First, you designate agents who will act for you. And by far, this is the most important of the 3 decisions. It's the most important one to get right. But we designate agents who will act for you. Second, we delegate powers. What can they do when they're acting for you? What authority do they have to act on your behalf? And third, we determine the timing. At what point do the named people have the authority to use the powers you've delegated to them? So who will act, what can they do, and when can they do it? For that first issue of designating agents, what I see most often as I work with clients, if they are married, they've named their spouse as their primary agent, right? And then they've listed their kids in order of ability. If they're single but have children, they just list their kids, right, in that age order. And I tell clients that spouse first and kids in the order of age is the right choice for everybody. If your kids were born in the order of their abilities, right? The oldest child is the best and then on down the line. That's a very poorly timed joke. But if you don't have your kids, right, born in order of ability, I still see it very often where clients list out their kids by age, but I ask them, why did you do that? And they say, because I thought I was supposed to. And then I ask, well, is the oldest child the right one to take care of these financial matters? Sometimes it is, that's the right choice, but often it's not. So I tell clients, when you're choosing agents, again, this is really the most critical issue in a durable power of attorney, is making sure you've got the right people to fulfill the necessary responsibilities. And so whether this is, in fact, your children or others, whether this is family, friends, or professional fiduciaries, whether it's people listed consecutively, right? This person followed by that person followed by another, or whether it's a series of like a team approach where you say, I'm going to have these two agents work together managing, right? And if one can't serve, then somebody else steps in and replaces them, or the other one serves alone. I think having a very detailed discussion with your advisors about who will serve as your power of attorney will be one of the most important things you do in terms of your estate planning.
Hey, Jared, can I ask you
Please.
a follow-up on that? Is
Absolutely.
how important do you think it is to have your agents near you, like within the same physical area?
Yeah,
What's your position on that?
great question. If all things are equal, I'm going to have a couple with two children, and one lives here close by and the other lives on the East Coast, and the kids are equal in terms of their ability and their trustworthiness and their skills and knowledge and all of that. I would prefer to have the child close as opposed to the one that's further away. However, if the one that's further away is more capable, right, is going to be the one that's better suited to carry out the administration of your affairs if you're incapacitated, I don't want the distance to be the determining factor then. I
Okay.
want the right person rather than the closest person. Because today, especially with financial matters, so much can be done online, can be done with DocuSign, can be done via email, that the distance isn't really a factor like it used to be.
Okay. Great.
Question. Yeah. When I will emphasize again, I think this is one of the most important decisions you'll make in your estate plan. And part of that is because when I see powers of attorney misused or outcomes go poorly, it's almost always because of the choice of the agent. It's rarely a mistake in the legal document, it's an error in who they put in that role. I'll also emphasize that there is no durable power of attorney police. Nobody's out supervising these. The courts are reactive, right? Courts will step in and respond to a lawsuit that's filed, but nobody is proactively making sure that these are handled correctly. And so, again, critically, you have the right people there, people that you trust. When you have the right agents in place, the second issue we have then is to delegate powers. We need to give authority to the agents to act on your behalf. This got easier a handful of years ago. In 2017, Washington State completely revoked their durable power of attorney statute. They did not amend it. They completely scrapped the old one and did a new one from the ground up. And part of what they did is they incorporated into Washington law the most traditional powers that are used in a durable power of attorney. It's the kind of things that if we just did a quick pop quiz and said, what do you think a power of attorney can do? And people started giving feedback, it's the kind of things that we'd all think about, right? They can manage real estate and banking and investing and taxes and litigation and insurance and annuities and retirement accounts and all these kind of just general financial management things. Washington codified these powers in state law. It's about 14 pages of material and it's extremely well written. They did a very good job when they put this into state law. It makes it much easier not only for attorneys to draft, but also easier for people to use in real life. Because if you take a power of attorney that uses these state law defaults and you're presenting it to a bank or a financial advisor, they no longer need to read all of the separate language from different attorneys and try and parse out what you're allowing your agent to do or not do. Instead, they're saying, oh, these are the state law defaults, and so we know what we're allowed to do. We know what the scope of the authority is. So I find it very helpful, again, not only for preparing documents, but for using them in real life. If your documents were done before 2017, you do not automatically need to redo them, right? When the law was redone, we grandfathered in everybody that had a document done before 2017 under the old law. However, I would recommend that clients consider reviewing them and seeing if these new provisions under state law would be helpful for them. The other thing that I'll point out quickly on these state law powers is when Washington codified all these powers, there were a few things that they left out of state law intentionally. The law recognizes that certain powers are often included in a power of attorney, but we did not codify them in state law. And so for these, if you want them, you do it the old-fashioned way, where you have an attorney draft in the language for you, identifying what you want done in that situation. There are three of these, what I call special powers, that I want to give just a little bit of emphasis to today. First, Washington, when they codified gifting powers, did a very, very simplified version of gifting. It basically allows agents to continue a pattern of giving that you've already established. However, not much beyond that. For many clients, lifetime giving will be one of the most powerful tax planning techniques they use for reducing or avoiding federal or state death taxes. And in Washington, if you have not expressly authorized your agents to make gifts on your behalf or to make larger taxable gifts on your behalf, then they are not allowed to do that. If you're using lifetime giving as part of your planning for reducing your estate to save taxes, that ends if you become incapacitated unless you've given your agents the authority to continue that, or maybe even to begin it if you become incapacitated. And so I strongly encourage clients, particularly clients with estates that are over the Washington exemption amount, currently 2,193,000. If you're over that Washington threshold, I strongly recommend that you consider reviewing your documents to see if this lifetime giving option is included, what the scope of it is. And if it's not there, then definitely recommend you talk with an attorney about including that, or what would be the pros and cons for you of having that. Other gifting powers would also include gifting for Medicaid planning purposes. I'm not going to go into detail on that, but certainly something that many clients are concerned about. There are two other special powers that I want to touch on very briefly. One is the power to change beneficiary designations, and the other is the power to modify other estate planning documents like a trust agreement or property agreement or something like that in your estate plan. This is one that's a little controversial. Clients will say to me, why would I, if I set up an estate plan, why would I want to let my agent have the authority potentially to change the estate plan? And my answer is, well, if you trust the agent, you're giving somebody else the ability to deal with your estate if circumstances change. I've seen many times where financial advisors change firms, right? And your money follows your financial advisor, but your beneficiary designations don't. Everyone knows what the beneficiaries need to be. They look at your old IRA or your old 401k and say, well, here's what the beneficiaries were, but we need to put that onto the new account. If you're incapacitated, you don't have the ability to do that, and neither does your agent unless you've expressly allowed it. The other thing is I've seen over my 21 years in practice that this is an area of law that changes constantly. In fact, there's a very bad joke. Please don't give me a courtesy laugh, but there's a very bad joke that there's only two kinds of lawyers found in a law library. One is new attorneys because they're learning the law, and the other is estate planning and tax attorneys because every year the law is changing. There's a lot of truth to that. Every time we change administrations, right, or Congress meets, we seem to be adjusting the estate tax and other estate tax planning related matters. And so if you're incapacitated, allowing somebody else to keep your plan current for these types of things, I think is very important to consider.
I think I would echo on top of that. Just I've
Please.
sat in several meetings with Jared and with other estate planning attorneys as well. And the idea of having flexibility within your plan is a really big deal. And
Yes.
in my opinion as well, just from a standpoint of things do change. And if you have the right people that you've elected to be your agents in these roles, hopefully they're doing the right thing for you and your estate and your family and everybody else. And you don't want to have their hands tied in case something does change. So
Yes. Yes. Good. So we've got our agents. We've delegated powers to them. The third issue is the timing. At what point can the agent start using the powers? This is one of the issues that comes up a lot that clients I find are uninformed about. They just haven't gotten good information as they've either learned online or talked with attorneys. With this delegation of the timing that people can act, I try and break down to clients in terms of three different options that you can use. The first option is by far the most common one historically. When I'm reviewing current documents, this is the one that I see most often. It's what we call a springing power. And it says that I've named agents and I've given them powers, but they can only use the powers if I become incapacitated. And then we need some sort of trigger event to show that incapacity. It's usually a doctor's note or a court order where the doctor has written off declaring you incapacitated or the court has done so. This was, again, by far the most common historically because it was sort of the right timing that clients thought they wanted. Nobody acts for me now. If I become incapacitated, then somebody steps in. The problem with this technique currently, and I've seen this evolving over my time in practice, is it's getting harder and harder every year to get a doctor who's willing to sign the note or to get a court that's willing to declare you incapacitated. Sure, if you're in a coma, it's easy. There's no question. If you've got full-on dementia or Alzheimer's, it's easy. There's a clear, you're clearly unable to manage for yourself. But as people age over time and slowly diminish in their decision-making ability, often they have lost the ability to manage their affairs correctly long before a doctor or a court is willing to declare them incapacitated. And so you have this in-between time where the agents really should be stepping in to help, but they're unable to because they can't get the trigger to happen. They can't get the doctor or the court to sign the note or the order. Attorneys, seeing this problem evolve over time, came up with a solution where they said, well, instead of a springing power, we'll just make we'll make powers of attorney effective immediately. Like you sign today and it's effective today. We never have to get the doctor or the court involved. And definitely that solved the one problem. However, I point out to clients when I'm consulting with them, that solves one problem, but it creates a different one. You could be at home perfectly competent and well to manage for yourself, but your agent is already stepping in, right? Because it's an immediate power, there's nothing that prevents them from acting on your behalf. For a long time, these two options, either the springing power or the immediate power, were all that clients had. And you just kind of pick the one that you hate less than the other. There was no perfect solution. It's just, two options and you choose the one that's the better of the two. Today, under the current law, there's a third option that we use that I find many of my clients really prefer. It's a blended version of the first two for married clients, where we will say between the couple, we'll make the power effective immediately. So you can always act for your spouse without having to get a formal declaration of their incapacity. Because in a long-standing marriage with a high level of trust, often that's what you'd want done. We don't need a third party involved. However, before the kids or the friend or the advisor steps in as power of attorney, we have a trigger for them where they need to get a doctor's note, a court order, or we often will put in a third option called a certification of authorization by principal, which is just a big mouthful for permission slip, right? This third option allows you to simply sign off and say, I am not incapacitated, but I now want my agent acting for me. If I get into that in-between phase where I'm not keeping up on my own affairs, but I'm not incompetent, I can't get a doctor to declare me incapacitated, I can sign off at that time and delegate the authority to the agent to act on my behalf. And I find a lot of people really like this because in real life, it sort of blends that high level of trust with their spouse with what's the old expression that fences make good neighbors, right? High level of trust for spouse, they can step in at any time. But before the kids or other agents step in, I want that fence, right? I want to decide when they step in, either I'm incapacitated or I've delegated the authority to them. All right, those are the three big issues in a durable power of attorney. Let's shift gears quickly and talk about next the healthcare power of attorney. This is the same concept as the general power of attorney, but now this is for medical decision-making rather than financial decision-making. But here we're still going to focus on the same three core issues. Who are the agents? What can they do and when can they do it? For the agents here, what I see most often is the clients have named the same agents on their healthcare power of attorney as they have on their financial power of attorney. And sometimes that's appropriate, but often it's not. Very often, particularly with an immediate family, the child that is most capable of stepping in and managing financial matters and working with your financial advisors and attorneys and accountants and others, right, to take care of you, is not the same child that you'd want making medical decisions. Sometimes it is, but again, often it's not. And so by separating these documents into two separate powers, right, a power of attorney for finance and another for healthcare, it allows us to name different team members for managing these different issues. We might have the one child or combination of children that are managing finance with a different child or combination of children that are managing healthcare. Again, I think this is something that should be discussed very openly with your advisors to ensure that you have the right people in place. Here, proximity matters a bit more, right? To have somebody step in long distance to manage your financial matters and they log onto the internet or they call or email your advisors or whatever else isn't terribly difficult. but having the long distance person to make medical decisions in an emergency, you might want somebody that's closer to home, or a combination of people where at least one of them is closer to home for you so they can respond easier in an emergency. After we have our agents in place, the second issue here is delegating powers. Again, what can the agent do or not do with regards to with regards to healthcare decision making? Washington, I think, made this very easy when they updated their statute. They codified all healthcare decision making for an agent in a single code section. It basically allows informed consent over healthcare decisions. It is very broadly drafted, which again I think is important so the agents can make all of those decisions that may come up. The one significant exception here is Washington does allow physician-assisted death, but does not allow an agent to consent to that on your behalf. So while your agent can provide pretty much any informed consent for you, they cannot artificially end your life. They can choose to not artificially prolong it, but they cannot choose to artificially end it. The other thing that I'll point out here about delegating powers is that in a healthcare power of attorney, I find it very important and helpful to also include some medical preferences, to give agents instructions on what your wishes are in certain more sensitive medical issues. For example, whether you want to be treated at home or in a facility for end-of-life care, whether you want to be an organ donor, whether the amount of life-sustaining treatment you'd prefer at time, at end-of-life decision making. Other decisions like that where it can lend itself to family disputes. I think it's helpful here not only to give the authority to the agent to make the decision, but also to give instruction to them on what you'd want done. This can be done in the document. Very often that's how I handle it. But also I will encourage clients to write a letter of wishes, right? Write out some of your more personal healthcare decision making, not so much as a legal document. This isn't notarized. It's not legally binding. It's just instruction to your agents telling them these are things that are important to me for my healthcare and or end of life care. That's also helpful because that can to have as a separate letter of wishes, because that can change over time. And if I've given authority in the healthcare power of attorney, but put wishes into a separate document, then I don't need to go back to my attorney and redo my document every time my medical preferences change. I can just update that letter of wishes or letter of instructions to the agents. Our third issue here for the healthcare power of attorney is the timing. When can these agents step in and act on your behalf? This is one of the only issues in estate planning that I personally believe is a one-size-fits-all. I really think that everybody in a healthcare power of attorney should have the same timing, and it should be effective immediately. And the reason that I feel strongly about that is because in real life, if you are able to communicate with your doctor, to express your preferences or to answer the doctor's questions, whether that is talking or blinking your eyes or squeezing a hand, if you're able to somehow let the doctor know your wishes, the doctor will be working with you. They don't need your agent acting for you. However, if you are not able to communicate with the doctor, I don't want the doctor to have to go through the extra steps or jump through the hoops of having to document that you're truly incapacitated. In an emergency, I want the doctor to be able to simply work with your existing agent, whoever's available. And so I like the healthcare power of attorney to be effective immediately. However, it will express in the document while it's immediate, it's always subordinate to your wishes if you're able to communicate. And that's how we balance that tension between letting you make your own healthcare decisions, but having a quick response in an emergency. Good. Two other separate healthcare documents that I want to talk about, still in this phase one personal planning. One is the healthcare directive, which we more commonly call the living will, and the other is the HIPAA authorization. The healthcare directive or living will is nothing more or less than your end-of-life care instructions. Basically, what it says is if you are terminally ill, and here by terminally, I don't mean a year to live, I mean death is imminent. Right? You're about to die. And that death is irreversible. There's nothing they can do to solve that. any treatment they provide would simply prolong the process of dying. Then the living will says, remove the artificial support and allow my body to die naturally. I want to be clear here. What you're removing is life prolonging procedures. They will not remove, for example, pain management, morphine, right? The living will would not interfere with that. This would be more like artificial nutrition or hydration or respiration or other life prolonging procedures like dialysis or blood transfusions or things like that. You're saying if I get to this end of life situation, then remove that support, allow my body to pass naturally. This is important because without this, you've shifted the burden of that decision to the healthcare representative, which can be a very emotional decision to have to make and can leave behind a burden of conflict or guilt for family. So I think having this instruction clear for them really resolves some of that angst within the family dynamic. The other form is the HIPAA authorization. This is simply a permission slip. HIPAA came about in 1996 originally, but for our purposes for estate planning, the relevant laws passed in 2003 and then were modified in 2004. And these were federal laws that said that all of your health records are confidential and can only be released with your permission. The difficulty that HIPAA imposed on estate planning is that it doesn't allow agents to access your information in order to make decisions for you. Imagine a scenario where your spouse or one of your children is in a hospital, right? You have had some health episode and you're there receiving treatment, and the doctor's looking to the agent for making the decisions of what to do, but is not allowed to disclose the medical records or information that agent needs. For example, if you had had a heart attack or a stroke, right, and the doctor says, well, this person could recover, should we provide care? And your agents are saying yes, but the doctor is not allowed to tell them that you also have terminal cancer and you're only coming back to finish the cancer treatments, right? That would certainly affect the decision-making process, but the doctor does not have authority to disclose that other piece of information. In a HIPAA authorization, we want to somehow give permission for doctors to release information to your agent so they can carry out proper decision making for you. There are two general ways to go about this. One is on a need to know basis, where basically we're giving HIPAA release to the acting agent in the moment. So we're saying when doctors are working with an acting durable power of attorney or healthcare power of attorney or trustee or other estate fiduciary, the doctors can release what that agent needs to know at that time for purposes of that decision. Again, a very limited need to know basis. It's kind of like open the door when you need to go through and close it behind you. The other way to deal with this is a list of authorized recipients where we waive HIPAA for purposes of the people on the list. For example, I might say, well, my spouse and my children are authorized recipients. That does not mean that they are all decision makers. It does mean that they all have access to information. Doctors are allowed to release information to them. And so whether you're doing a narrower or a broader approach, I think that the HIPAA authorization is a critical component of a well-written estate plan. Good. I'm going to go back now. So that wraps up our phase one, our personal planning. That moves us to our second area of estate planning, which is asset distribution. And here, this is the part of the plan for after you pass away. What legal documents do we use to direct the division and distribution of your estate? The two primary documents that clients want to talk about here are wills and living trusts. And I probably have this discussion at least 4 or 5 times every week, trying to help clients understand the real differences between a will and a living trust so they can make an educated decision. I find this is the area where there's the most misinformation out on the internet. And so if you have asked Siri or Alexa or ChatGPT, right, for your legal advice here, you might want to go back and flesh out the details at least. The 3 most common issues that I have come up when I'm talking with clients about a will versus a living trust for their estate plan is tax planning, asset protection, and probate avoidance. Clients will say, well, I want a living trust for tax planning purposes, or I want a living trust for asset protection or for avoiding probate. And I tell clients, two of these are simply misinformation, and one of them, there's some truth to it, but you have to put it in context to really understand it. To make short work of this so we can stay on time, there is absolutely no tax planning difference between a properly done will and a properly done living trust. Or said in other words, if you've done the estate plan correctly, whether it's a will or a living trust, you can get the exact same tax result, penny for penny, every time. I do not care what else you may, this sounds arrogant, I don't mean it this way, but what else you may have heard or read or whatever else, where there's all this information about using a living trust can save you taxes. That is simply incomplete information. You can do tax planning inside of a living trust, but you can do the same tax planning penny for penny every time with a properly done will. So when clients say, I want a living trust for tax planning purposes, I tell them that is not enough. That's not enough of a reason to get a living trust. Asset protection is also a misnomer or misinformation. There's absolutely no creditor protection or asset protection using a revocable living trust. A revocable living trust is revocable by you while you're alive. And so just as you could reach in and get the assets, so could the court if you were being sued. So it offers no liability shield. And after you pass away, both a will and a living trust have the same statutory option for notifying creditors of the death and going through a shortened statute of limitations to reduce the creditor claim period. So again, there is no difference with a will or a living trust in terms of any asset protection. The third issue, probate avoidance, is the one where there is truth that there's a difference between a will and a living trust. However, there's also a lot of misunderstanding on what that means. When clients say to me, Jared, I want to avoid probate, my first response is usually, do you know what probate is? And on occasion, clients do, but usually they say, I've heard about it, but to be honest, I don't have a whole bunch of details. Let me walk you through just a quick overview of what happens when you settle an estate when somebody dies. There are three big responsibilities. Whether you use a will or a living trust, there are three big responsibilities for settling an estate. First, when somebody passes away, we have to gather all of the assets that they owned and create an inventory. With a will, this is a formal process of establishing the inventory, right? That is not filed with the court, but state law does create a time frame that inventory has to be complete. With a living trust, there's also a formal process of creating inventory that has to be completed within a certain amount of time. And in both cases, that inventory must be available not to the court, but available to the heirs or beneficiaries, right, of the will or the trust. So in short, whether you're doing a will or living trust, we have the same responsibility to gather assets and create an inventory of everything the person owned. Second, once we have everything the person owned, we have to pay off everything they owed at time of death. That means we pay off all of their debts, all of their expenses, and all of their taxes. Debts would be things they owed outstanding at the time of their death. Expenses are the costs of settling the estate, whether it's the cost of probate or the cost of trust administration. It's the cost of the accounting and legal and other fees, right, for settling out the estate. And then taxes, we know what those are. Again, there is no difference in the responsibilities for somebody paying off what you owe, debts, expenses, and taxes when you pass away, whether it's a will or a living trust. And then the third issue, we've gathered what you own, pay off what you owe. The third thing is to distribute the balance to the intended beneficiaries, where we have to take the leftovers and give them under the terms of the will or under the terms of the living trust to the intended recipients. Again, that process of distributing the assets does not change whether it's a will or a living trust. Because the work is the same for gathering and paying off and distributing, I tell clients the time involved and the cost involved for a probate of a will or the administration of a living trust is almost identical. there's really no significant difference in terms of the time or cost for settling a will or settling a living trust in Washington state. And this is where we get the misinformation. Clients will say, yeah, but I've read on the internet, tons of information about how you can save, months and months of time, and you can save tens of thousands, sometimes hundreds of thousands of dollars in cost by having a living trust instead of a will. That all can't be wrong, can it? And I say, no, the information that you're reading is probably accurate. It's just not Washington information. Washington has one of the most simplified and efficient probate systems in the United States, which is why the system in Washington for a probate mirrors the system for settling a living trust. However, other states, many other states have very antiquated and complicated probate systems. I'll give you just a quick example to illustrate my point. In California right now, and I don't practice in California, but I kind of keep tabs on them because it illustrates well for clients the difference. A couple of weeks ago, I was talking to a financial advisor in California, and I ran this information by him just to see if my information was current. But I asked, how long does it take in California right now if somebody dies with a will from the time of death until the time that we can open the probate? When do we get the hearing in front of the judge to start the probate? And he said, well, Jared, I'm in Southern California right now, and it's a little over a year. So if you, yes, if you pass away in February of 2025, we will open the probate sometime around Valentine's Day or St. Patrick's Day of 2026, right around a year or a little over. And there's nothing that we can do to speed up that process. We schedule the hearing with the court as soon as the death has occurred, and we just schedule with the next available hearing, which again, he said is about a year out, a little over. In Washington, we do not do that. We have an ex parte system, which just means an open court system. And if somebody were to pass away in Washington today, if there was not a dispute or a contest, we could have the probate open within 4 to 6 weeks at the most. Very often it's 3 or 4 weeks, right? And so this idea of a long delay that, probate causes isn't accurate in Washington because we can get into the court and schedule so quickly. Even in the middle of COVID, when everything was shut down, I never waited for the court more than about 10 days from when I filed to when I heard back. I also don't go in for a hearing. There's an online system now with King County where you can just mail the will to the court and then upload documents online and download the judge's response. So again, even in COVID, I never waited for a judge more than about 10 days. The other thing is in other states like California, you pay for the probate as a percentage of the value of the estate. In California right now, the first $1 million, the legal fees are $23,000, and it's 1% for each additional million. So you can imagine how quickly probate fees legal fees rack up in California. On a $5 million estate, $23,000, $33,000, $43,000, $53,000, $60,000. In Washington, attorneys bill on an hourly basis, and we won't get anywhere near the cost of a California probate. So when you read online about avoiding months of time and tens of thousands of dollars of cost by avoiding probate, I say that's accurate in states like California. In Washington, the probate and the trust administration are both very simplified.
So Jared, in that example, and by the way, I know we're running up against time, but you do not need to rush. We can keep going all the way till the top of the hour if that works for other people. It's not a rush at all. But in that example, if they're in California and instead of having a will, they had a living trust and their assets were titled in that living trust, they would have avoided.
Correct.
That
the living trust avoids the probate because you don't own it in your own name.
Right.
And so you have, as Chad is saying, you have the living trust, the assets are titled in the living trust, and the trust then does this private administration. It directs the payment of expenses and taxes, distribution to beneficiaries without the court's involvement.
It's not as big of a deal in Washington because it's just not that big of a deal compared to these other states. So I just think I think that's really important. I hear that all the time as well. So I think it's just important for people to kind of understand the distinction.
Yes. I still do, in my firm, we still do a fair amount of living trusts. I would say probably 20 to 25% of these state plans are living trusts. Mm-hmm. Even after I walk the client through, hey, here's the reasons you don't need one, that a will is adequate. Because there are two situations where in Washington, a living trust still adds real value. one that I come across all the time, and the others more isolated, more rare, but it's still important on occasion. The one that I see very frequently is clients with property in multiple states. I have a huge percentage of my clients that have a home in Washington and a home somewhere where it's always sunny, like California, Nevada, Arizona, Texas, and sometimes they've got a handful of properties spread out across the United States. And I tell the clients, well, now you have a probate in every state where you have a property. So when you pass away, you've got a Washington probate and an Arizona probate, and the cabin in Idaho needs a probate as well, right? When I have property in multiple states, then having a living trust and consolidating all of that will be a good investment because you'll save money in the long run. But when everything's consolidated in Washington, you just don't have that same issue. The other one that comes up very rarely, but when it does come up, it's important to clients, is a matter of privacy. When you die with a will, the will is filed with the court, and at that point, it's public record. People cannot see how much you're worth or where the assets are, but they can see how the estate is being distributed. Well, if you go back, I don't know, 10, 12 years ago, I've lost track of time, but when Paul Allen passed away, it was all over the radio that he had a living trust. And people speculated about his tax savings. And I smiled and thought, no, it wasn't about tax planning. It was about privacy. Paul Allen did not want people to see where he left his wealth. I do not have any estates anywhere near the level of Paul Allen, but I do have clients where they say, it's important to me that I keep this information private. I have an ex-spouse or a former business partner or an in-law or relative who will cause problems in my estate, and I want to keep it private, and so I'm willing to get a living trust to buy that privacy.
Hey, Jared, those are great examples. I have a question that came up while we
Please.
were talking on this. Here it is. It's if a person has a living trust that was created in California, but that person is now a Washington resident, where would they have to file probate? I don't know if does that make sense, that question?
Yes, it does.
Okay.
So I've got a Washington living trust, but they're now living in, sorry, California living trust, and now
Yeah.
living in Washington.
Yes.
Right? Where would that administration occur?
Yep.
Assuming that the trust is properly funded, we would look to the trust agreement itself to see where it designates administration to happen. So likely the California Living Trust would say it's administered under California law.
Got it.
So yes, I would recommend at least having it reviewed. It may be something where we simply need to amend it to say it's administered under Washington law. It may be
Okay.
something where there's been enough change in the estate it needs to be updated, but I would certainly encourage the client to have it reviewed.
Got it. Great.
Yep.
Thank
Good
you.
question. Our third area of planning is beneficiary care, or what I call parenting from the grave, right? This is the part of the estate plan where your will or your living trust has said, this is who's getting the assets, right? I've divided the pie, but now I'm going to serve it, right? What are the rules in terms of handing it over to the intended beneficiary? And here there are three ways to turn an asset over from the estate or trust to the intended beneficiary. And there are only three. There isn't a magic fourth option that I'm hiding, right? When you turn the asset over to somebody else, you're either giving it outright, you're giving it to a custodian under the Uniform Transfer to Minors Act, or you're giving it to a trustee who administer it in trust. With the outright option, it is exactly what it sounds like. I die, I give it to this other person, it was mine, now it's theirs. I might hope they use it in a certain way. I might wish that they do or don't do things with it, right? I might write a letter of wishes or instructions on how they're to administer it, but I have no control. There is nothing legally enforceable. If I leave it outright, it is simply theirs. Now, that is by far the easiest and the simplest way to distribute an estate, right? But again, I have given up full control once I hand it over. The second option is giving the funds to or the assets to a custodian who will manage them under the Uniform Transfer to Minors Act. This is very cost effective, like outright. It's easy to draft and easy to administer, but I get to retain a small level of control. Here, I can designate the custodian hold the asset until the minor turns either 21 or 25. During that time that it's being held, the custodian has the discretion to use the assets for the minor's health care or education or other support needs. But it's that custodian, almost like a parent, right, that gets to decide when and how much to use. At age 21 or 25, whichever election has been made, the account simply removes the name of the custodian and it belongs to the minor, who now has full control. This is helpful, though, because for relatively modest amounts, I do not need the cost or complexity of a trust. I can still have the funds supervised until the minor is, I prefer 25 over 21, right? But until they're of an age where they're more prepared to administer the asset. So again, I really like this option.
Is a custodian typically, in your experience, a family member that you
Yes.
would designate? Is that typically what you see?
Yeah, this is usually if it's me as the parent, it's one of my siblings, or maybe an older sibling for a much younger one.
Okay.
But it's some other trusted adult that's managing it for the minor.
Yeah. Okay.
Yep. Again, relatively low cost, easy to set up, easy to administer, but it gives some control so the person can grow into the wealth. Chad, I guess I can't speak for globally here, but you mentioned I have 6 kids, and 3 boys, 3 girls, my wife and I. And so at least for that small sample set of 3 boys and 3 girls, I will say that including my 3 boys who are wonderful and I love them, I have never met among those 3 or any other 18-year-old boy that I've met where I said, you know what that 18-year-old boy needs? He needs an inheritance. I've just never had that experience. So 25's a little better, right? But certainly 18 is a bit young in my mind to be handing over wealth. The third option is a trust. And I want to be clear here. When I say a trust here, this can be either part of a living trust or part of a will. This is a trust that's created after the death. Either the living trust says, I'm giving the leftover to another trust for the beneficiary, or the will says, I'm giving this person's share in trust for them. So I don't need a living trust in order to have a trust here. This can be, again, part of a will or living trust. But this is very customizable. This is where I can, in an estate plan, designate a trustee to manage somebody's inheritance with whatever rules that I want to set up. So I can spread it beyond age 25, and I can be more precise about when and how the money is used. This is my preference when it comes to larger estates. When I'm leaving $1 million or $2 million or $3 million or more to a beneficiary, and I'm saying 25 isn't old enough anymore. I want them to grow into the wealth over time, part at 25, part at 30, part at 35. Or I want to be more customized in terms of, I want this amount used for education. I want this other used for a home purchase. I want this other used for these other needs or purposes. So this really allows us to leave more of a meaningful legacy where we're determining how we want that, when and how we want that wealth transferred. That is the end of my slides, but I would like to open it up for questions or comments or clarifications from anyone in our audience there.
Yeah, I don't know that I see any other questions or thoughts here, at least on my end. Oh, let's see here. Somebody raised their hand. Let me see here. Deb, can you put a question in the chat box or the Q&A? Is that a possibility? Should be there on the bottom. I can't call on anybody in this system, unfortunately. I saw the raised hand though. Well, oh, here we go. Got in there. Cost estimate to review and revise an estate. That's the question.
Good. In our firm, we do the review on a fixed fee. So there are 4 attorneys in the firm, me and then 3 associates, and each of us offer a review on a fixed fee. The fee is $500 for the review, and what that includes is a review of the existing documents, and then a detailed discussion with the client about what their plan says now and what other options or recommendations we have. Just like today's session, our goal in that initial consultation is really to educate. Whether you decided to go forward with us or you decided to go back to your prior attorney or you decided to do nothing at all isn't really critical to us. It's critical that we give you good information about here's what your plan currently does. Here's, again, considerations or holes in the plan or, whether it's legal or preference. We really want you to walk out with this good education on your existing estate plan. Fees for revising it if there were changes needed, that's harder to estimate because it really depends on what's changing. In our firm, we do not do flat fees beyond the initial consultation. Everything after that is on an hourly basis. But in my opinion, that allows us to be more customized for the client, right? Where we aren't driving for a product so much as providing a service, where we're saying, hey, this is what we see that needs to be done, and then we give an estimate for that work involved.
Right. Was that okay, Deb? Okay, got one more coming in here. Okay, is it okay to have co-executors slash administrators if the two executors have a good relationship? Pros, cons of co-executors versus having one.
Yeah, that is a great question. I'm glad somebody asked it. Um, uh, I have heard feedback from some attorneys, just as we've chatted at social events or legal education or whatever, where they strongly discourage clients from using co-agents. I do not. I actually have seen that work very, very well when the relationship is good. When clients say, "Look, I've got these two children. They work well together. They bring different skill sets to the table. One is more mindful of this, the other's better at that," and the team of them would get the right result. I'm all in favor of using the team then. And again, in my practice, I've seen that work very, very well. My caveat to that is have the discussion with the kids. Sometimes the parents think, hey, these two get along great, only to talk with them and find out that either the relationship isn't strong in that way, or the one simply doesn't want to be part of it. Says, no, no, I trust my sibling, just let them do it. But having the discussion with them so that they're aware that that's what you're considering. Also, caveat, I've had a few clients where they say, these two kids don't get along at all, so I'm going to put them together so they have eyes on each other. That's not a good idea. If they don't get along at all and they're just not going to work well together or separately, then maybe consider somebody else, including maybe a professional advisor, not an attorney, but like a trust company that can provide the service. But yeah, when kids work well together, I like having them as co-agents. When you have agents serve consecutively, right, spouse, then one child and the other child, it's much more efficient, much easier to work with in real life than having co-agents. However, with co-agents, you get that benefit of, the two heads are better than one, the transparency between them, and then being able to delegate and kind of divide and conquer the responsibilities. So
The other thing that Jared didn't note too is being an executor, which I've been four times now in my lifetime, is a big job. There's a lot of work involved, so that's a whole nother piece to that pie, whether it's co or single or what have you. There's just a lot of work to be done there. So just remember
yes, there
that.
is.
We have another question is can I bring my main beneficiary to a meeting to discuss the option? I guess, Cheryl, I'm not sure what option you're referring to there, but does that make sense to you, Jared?
Yeah. So I think what's being asked is it okay to have beneficiary or others there at the discussion with the attorney? Um, yes, I actually encourage that. The caveat to this one is if you have somebody else in the meeting, you void the attorney-client privilege. So things that are discussed just with an attorney stay confidential. They cannot be disclosed in court or other places. And so a lot of attorneys really frown on having third parties in the meeting because they don't want to lose that attorney-client privilege. I'm less concerned about that unless we're expecting a lawsuit. For most estates, I actually welcome having the financial advisor or other trusted advisor or one or more of the kids that are going to be part of the process. I think that it's helpful for them, not only the input that they'll provide, which is helpful for me, but also helpful for them to be involved in the discussion process, to see what the plan is, to be aware of why things were decided the way they were, so that when the time comes and you're not there to be your own voice anymore, this person says, no, no, I was part of the process. I saw what was done, and I know that this was mom or dad's wish. Also, when the attorney's not there, having that second set of ears, so the child can say, no, no, remember the attorney talked about this, or we decided this other thing. I think is really helpful. Same with a financial advisor. I actually welcome it.
Well, great. Well, we are up against the hour. I just want to thank everybody for taking the time to visit today. And I would say, Jared, this was exactly what I was looking for from you.
Good.
You were absolutely educational. I wrote down a lot of new notes. And by the way, this is the typical experience when you come in to see Jared is going through this educational kind of world to understand what it is you're getting yourself into. Because I think most people jump into estate planning and they start thinking wills, and that's it. And I think that's my experience has been what I appreciate is there's a lot of planning that goes into play while you're still around
Yeah.
when you die, and subsequently how you want to have things handled for your family members in the longer term. And I think that was super useful for me. I really appreciate, and hopefully for everybody else that's on here. We did tape this presentation, by the way, everybody. So we will send a copy to all of you, and it will be on our website as well. And Jared, I just really want to thank you for taking the time to go through your thoughts. I thought your examples were great today, by the way.
Well, thank you. Thank you again for having me. I appreciate it very much.
Yeah. Well, thank you all very much. Hopefully everybody dries out a little bit today, and thanks for joining us on our first quarter webinar 2025. Thanks again. Appreciate it. Thanks,
Thank
Jared.
you.
Okay. Bye-bye.